3. So we are starting our part 4, but we are still in volume 3. So anybody following along, this is page 88 of the report, 97 of the PDF. We just went over this last part on stream. It was talking about the Nixon v. United States 506 U.S. 224-234 1993, where referenced, quote, the framers recognized that most likely there would be two sets of proceedings for individuals who commit impeachable offenses, the impeachment trial and a separate criminal trial. So we will continue on from there because that is the spot that we left off last time. Beautiful. Now that everybody's caught up and everybody's tuned in, welcome, welcome. Appreciate you. Let's hop to it. Ooh, first things first. Hydrate to be great. The impeachment judgment clause itself expressly contemplates separate proceedings, stating that the punishment for impeachment and conviction, quote, shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law, end quote. U.S. Constitution, Article 1, 3, Clause 7. Moving on. Not only are impeachment and prosecution separate and distinct proceedings, they apply different standards and pursue different objectives. When Congress decides whether a president should be impeached and convicted, that process does not depend on rigorously adjudicating facts and applying law or on finding a criminal violation. Instead, the impeachment process is, by design, an inherently political remedy for the dangers to governance posed by an office holder who has committed, quote, treason, bribery, or other high crimes and misdemeanors, end quote. U.S. Constitution, Article 2, 4. Congress may decide not to impeach or convict for reasons that have little or no connection to the nature of the evidence of the officer's culpable conduct. For example, the political alignment of Congress may prevent impeachment and conviction without regard to the officer's conduct. So they looked at bias when they went over this. You can see it right here. Indeed, prior to 2020, no senator had ever voted to convict an impeached president of the same political party. And in cases like this one, where the president has left office by the time an impeachment trial occurs, senators may question their authority to convict regardless of the egregiousness of the conduct at issue. See example 167, geez Louise, statement from Senator McConnell. So Senator McConnell directly talking about this issue. Gotta love it. During Mr. Trump's impeachment trial, his counsel insisted that the outcome of the proceeding would have no bearing on any future criminal prosecution, stating, quote, clearly, a former civil officer who is not impeached is subject to, end quote, criminal prosecution. 167, February 9th, 2021. Statement above, or referenced above, noting that if a president, quote, committed a criminal offense, end quote, then, quote, after he is out of office, you go and arrest him, end quote, adding, quote, the Department of Justice does know what to do with such people, end quote. Senators who voted to acquit Mr. Trump expressed a similar view. See 167, just referencing a bunch of comments from people from Congress. That's what it is. So this is Senator McConnell stating that, quote, stating that Mr. Trump, quote, is still liable for everything he did while he was in office as an ordinary citizen, end quote. And noting that, quote, we have a criminal justice system in this country, end quote. Good load of shit that did. It did a whole lot of good, didn't it? Thus, even if Mr. Trump has been convicted by the Senate, political accountability in the form of impeachment would not have been an adequate alternative for criminal accountability, especially considering the scope of Mr. Trump's offenses and the substantial federal interests they targeted. Part D of Volume 3. Mr. Trump's conduct had no historical analog. During pretrial litigation, Mr. Trump contended that his conduct was materially indistinguishable from that of other actors throughout American history, including past presidents and vice presidents, who had either claimed that an election was tainted by fraud or presided over a certification proceeding at the joint session where electoral votes were in dispute. Mr. Trump further argued that because those actors had not been prosecuted for their purportedly similar conduct, it would be unconstitutional to prosecute him for his conduct, because doing so would either violate his right to fair notice or result in selective or vindictive prosecution. That is, even accepting that Mr. Trump engaged in the conduct alleged in the indictment and that such conduct violated the charged statutes, he maintained that prosecution was improper because it conflicted with historical practice. So even if I broke the law, so did other people, so you can't come after me. That's what he's saying, I guess. Trash person. The historical episodes that Mr. Trump invoked, arising from elections in 1800, 1824, 1876, 1960, 2000, 2004, and 2016, did not involve similar conduct and did not supply a valid reason to decline to bring charges here. In litigation, the office addressed each historical episode he cited and explained why none was meaningfully similar to the charged conduct. See ECF number 139 at 40 through 70, 40 through 47. Don't know why that was so tough. ECF number 141 at 6 through 9. Taken together, those episodes showed that, quote, there have been times, as in 1800, 1876, and 1960, when genuine questions have arisen over which slate of electors from a particular state has been duly appointed, end quote. Quote, there have also been times, as in 1824, when the failure of any candidate to obtain a majority of electoral votes has thrown the election to the House of Representatives, end quote. And, quote, there have been times, as in 2000, 2004, and 2016, when those dissatisfied with the results have sought to raise objections to the electoral vote count, resulting in either the objections being overruled or, in one case, a brief adjournment designed as an Ohio-focused protest vote without, quote, the hope or even the hint of overturning the victory of the president, end quote. ECF number 139 at 46 through 47, quoting some congressional shit from January 6, 2005. But none of the historical episodes at issue involved, quote, any attempt by any person to use fraud and deceit to obstruct or defeat the governmental function that would result in the certification of a lawful winner of the presidential election, end quote. So they went through all the examples that Trump gave as, hey, other people did this in the past, so I'm allowed to do this. And they said, no, these don't fit. If anybody has any problems with those, we can always go through any one of those. But they listed all the examples that they gave as their justification and then went through each one of them and said how they were different. It sounds good enough for me. The district court found that there were no historical analogs to Mr. Trump's alleged criminal conduct. When Mr. Trump filed a motion to dismiss the indictment on a claim that he was being selectively prosecuted because of a historical, quote, track record of similar unprosecuted efforts, end quote, to challenge elections, see ECF number 116 at 6, the district court rejected it, explaining that Mr. Trump was, quote, not being prosecuted for publicly contesting the results of the election. He is being prosecuted for knowingly making false statements in furtherance of a criminal conspiracy and for obstruction of election certification proceedings, end quote. ECF number 198 at 5 through 7. Likewise, in its opinion denying Mr. Trump's immunity motion, the district court found that, quote, none of the contested elections, end quote, Mr. Trump, quote, invokes is analogous to this case, end quote, as none involved, quote, any allegation that any official engaged in criminal conduct to obstruct the electoral process, end quote. So what you're bringing up has nothing to do with what they're saying. That's how they end that section. So that's the end of volume 3, is that as none involved, quote, have any allegation that any official engaged in criminal conduct to obstruct the electoral process. So there's no example of what you're talking about in any of the justifications you're giving. They're not related to this, so it doesn't track. It's a bunch of bullshit, is what they're saying in the legal terms. That's what I'm reading. So we are moving on to volume 4, investigative procedure and policy. Upon appointing the special counsel, the Attorney General explained that the appointment, quote, underscores the department's commitment to both independence and accountability in particularly sensitive matters. It also allows prosecutors and agents to continue their work expeditiously and to make decisions indisputably guided only by the facts and the law, end quote. See press release, Office of Public Affairs, Department of Justice, appointment of a special counsel, November 18th, 2022. A bunch of other shit. The Attorney General also noted that, quote, although the special counsel will not be subject to the day-to-day supervision of any official of the department, he must comply with the regulations, procedures, and policies of the department, end quote. The office conducted its work accordingly. Part A of Volume 4, the investigative process. Employing traditional investigative tools, including voluntary interviews, grand jury subpoenas, and search warrants, and subject to the same legal requirements binding on all federal prosecutors, the office, spanning the period predating the special counsel's appointment to the completions of its work, developed a thorough record of independently verified facts on which it based its prosecutive decisions in the election case. The investigative record comprised voluntary witness interviews and grand jury testimony from numerous individuals, as well as voluminous records. Sorry, that was a goofy one. Voluminous records such as emails, text messages, encrypted messages, memoranda, and other documents. These records were obtained through both voluntary productions by dozens of witnesses and through compulsory process and court orders, including grand jury subpoenas directed to witnesses and entities, court orders for non-content information, such as render, recipient, date, and time, from electronic communications accounts, and search warrants to obtain evidence from physical sources and or locations, electronic devices, and email and iCloud accounts. The office also obtained records from other components of the Department of Justice, including the U.S. Attorney's Office for the District of Columbia and other federal agencies, including the National Archives, Department of Homeland Security, Department of Defense, and Office of the Director of National Intelligence. Further, the office collected more than 1 terabyte of data from publicly available sources such as social media postings and websites. All discoverable material was provided or made available to Mr. Trump in discovery during the prosecution of the election case. Throughout its work, the office complied with, quote, the rules, regulations, procedures, practices, and policies of the Department of Justice, end quote, 28 CFR 600.7a, including consulting the Justice Manual, the department's publicly available guidebook on policies and procedures, and consulting or obtaining requisite approvals from other department components. For example, as required under the Justice Manual, the office obtained approvals from the Criminal Division's Office of Enforcement Operations, which provides legal guidance on the use of sensitive law enforcement tools, such as certain subpoenas and search warrants involving attorneys. And, as discussed more below, the office consulted the Criminal Division's Public Integrity Section, PIN, Public Integrity Section, PIN, P-I-N is what they're calling it, which oversees the investigation and prosecution of federal crimes affecting government integrity, pursuant to Justice Manual requirements pertaining to the service of subpoenas and other process of members of Congress, the use of election fraud charges, and the department's election year sensitivities policy. a long-standing department policy regarding the conduct of sensitive investigations during an election year. Boom. So be careful. PIN, I guess is what they're shortening that to. I'm going to try and remember that. Criminal Division's Public Integrity Section, PIN, which oversees the investigation and prosecution of federal crimes affecting government integrity pursuant to Justice Manual requirements pertaining to the service of subpoenas and other process on members of Congress, the use of election fraud charges, and the department's election year sensitivities policy, a longstanding department policy regarding the conduct of sensitive investigations during an election year. Okay, moving on. Even when not required, in accordance with the best traditions of the department, the office actively sought advice and guidance from subject matter experts throughout the department. For example, the office requested assistance from the Civil Division and Office of Information Policy, OIP, on civil litigation for public access to investigative and prosecutive materials. And the office conferred with the Office of the Solicitor General, OSG, which is responsible for supervising and conducting government litigation in the United States Supreme Court, the Office of Legal Counsel, OLC, which provides binding legal advice to the executive branch, and the Criminal Division's Appellate Section, which conducts and oversees the department's criminal appellate litigation on complex statutory, constitutional, and other legal issues, including regarding charging decisions in the original and superseding indictments. See Supra at Section 2. Mr. Trump's challenge to the district court's order on extrajudicial statements, see Infra at Section VB, Mr. Trump's executive privilege claims, see Infra at Section VC, and Mr. Trump's immunity challenge to the indictment, see Infra at Section VD. Part B of Volume 4. Investigative and prosecutive procedures in an election year. So this is going to talk about how they didn't try and meddle with an election, for all the people who say they did. And I know a lot of people that should hear this won't hear this, but we're going to get it out there anyway. Mr. Trump's announcement of his candidacy for president while two federal criminal investigations were ongoing presented an unprecedented challenge for the Department of Justice and the courts. Given the timing and circumstances of the special counsel's appointment and the office's work, it was unavoidable that the regular processes of the criminal law and the judicial system would run parallel to the election campaign. So right there, given the timing of the special counsel's appointment, is that just him saying that it's Merrick Garland's fault? That's what I'm writing down in my notes. Merrick Garland is to blame? Let's see if Jack Smith would stand by that. I don't know. I'm not saying he said that. I'm wondering. Put a question mark after that. All right. Moving on. Mr. Trump's position was that when the judicial process conflicted with his election campaign, the courts should always yield. As discussed below, the courts did not agree. Under these unique circumstances, the department's actions would be criticized by one constituency or another, regardless of which path the investigations took. Accordingly, the office leaned on established department policy, practice, and wisdom, and focused on doing its job promptly and thoroughly. So, would have been pissed either way. You can't not investigate it because then the Dems would kill you. You can't go too fast or too much because the repubes will kill you. So they tried to just do their job. From the outset and throughout its work, the office recognized the weighty issues presented by the matters under its mandate and operated on the principle that the best interests of the department and the nation required prompt investigation and decision-making. The office's exceptional working pace ensured that its investigative work could be completed charging decisions could be made, and any necessary indictments could be returned by the summer of 2023, long before the election. The office had no interest in affecting the presidential election, and it complied fully with the letter and the spirit of the department's policy regarding election year sensitivities. It did so through fundamentally sound practices, moving its investigation swiftly, making charging decisions and returning indictments well before the election, litigating its cases on the timetables set by the courts, and consulting with Penn. So I think this is Volume 4, Part B, Subsection 1. I think. I'm almost certain. Yeah. Okay. Volume 4, Part B, Subsection 1, getting into it. The department's election year sensitivities policy. The staff of the office was deeply familiar with and committed to the department's election year sensitivities policy, as it included fraud and public corruption prosecutors with many years of experience working in and leading Penn. The special counsel himself and one of his counselors had served as chief of Penn. 2 of the attorneys had been deputy chiefs in Penn, and 2 other attorneys in the office had been trial attorneys in Penn. Collectively, prosecutors in the office had many years of experience providing training, advice, and guidance to prosecutors and law enforcement agents throughout the department on how to comply with the department's election-related policies. In fact, the counselor in the office who had previously served as chief of Penn was one of the drafters of the first election year sensitivities memorandum issued to department attorneys. The department's policy regarding elections has 2 overlapping components. The first is focused on the prosecutor's purpose. It prohibits prosecutors from taking any action or timing any action for the purpose of affecting an election. Justice Manual 9-27 2.260 and 9-85.500. That flat prohibition applies to all actions by prosecutors and at all times during an investigation or prosecution. The second and overlapping component focuses on safeguarding the department's reputation for fairness and nonpartisanship, requiring that prosecutors take particular care in an election year and consult with Penn when an action is, quote, likely to raise an issue or the perception of an issue, end quote. Yeah, where is that when oh gosh, am I gonna blank on his name? That's the real question. Comey, with the Clinton investigation. I wonder what that was. How is that true to this policy here? I would wonder what that is. Get everything loaded back up here. Because by this, it doesn't really seem like you could have it be, oh, I want to get things out and I need to get them out before the election because I want people to have this information right before the election. It really seems like, by the way that's written, you wouldn't be able to do that. Likely to raise an issue or the perception of an issue. Justice Manual, blah, 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 blah. A bunch of shit that I didn't sign up for, but he did. Anyway, moving on. These policies are well established within the department. In 2008, in the wake of allegations and investigations concerning politicization in the department and recognizing that there was uncertainty regarding the terms of the department's policies and practices in election years, the Criminal Division and PIN evaluated the feasibility of establishing a specific and definitive set of rules regarding the duty to avoid interference with elections in the run-up to an election. While prosecutors had long been advised to exercise particular care in politically sensitive cases in the 2 or 3 months immediately prior to an election, the department had never had a formal 60-day or 90-day rule that governed such situations. As part of its evaluation in 2008, the department considered whether to codify a particular rule, but ultimately concluded that the best course was, instead, to provide guidance in the form of an Attorney General memorandum addressing the need for particular care to protect the department's reputation for impartiality in an election year, and setting forth in writing the core principle that prosecutors and agents may not act for a political purpose. So make sure you don't get that one written down, is what they decided. My goodness. On March 5th, 2008, Attorney General Michael Mukasey, I don't know, issued the first election year sensitivities memorandum, setting forth this guidance. In relevant part, the Attorney General memorandum stated, Department of Justice employees are entrusted with the authority to enforce the laws of the United States and with the responsibility to do so in a neutral and impartial manner. This is particularly important in an election year. Now that the election season is upon us, I want to remind you of the department's existing policies with respect to political activities. The Department of Justice has a strong interest in the prosecution of election fraud and other election-related crimes, such as those involving federal and state campaign finance laws, federal patronage laws, and corruption of the election process. As department employees, however, we must be particularly sensitive to safeguarding the department's reputation for fairness, neutrality, and nonpartisanship. Simply put, politics must play no role in the decisions of federal investigators or prosecutors regarding any investigations or criminal charges. Law enforcement officers and prosecutors may never select the timing of investigative steps or criminal charges for the purpose of affecting any election or for the purpose of giving an advantage or disadvantage to any candidate or political party. Such a purpose is inconsistent with the department's mission and with the principles of federal prosecution. If you are faced with a question regarding the timing of charges or overt investigative steps near the time of a primary or general election, please contact the Public Integrity section of the Criminal Division for further guidance. Memorandum from Michael Mukasey, Attorney General, Election Year Sensitivities, March 5th, 2008. Since 2008, Attorney Generals have issued memoranda containing substantially the same guidance to prosecutors and agents in an election year. In August 2022, just 3 months before the Attorney General appointed the special counsel, the department codified its election year policies in the Justice Manual. Federal prosecutors and agents may never select the timing of any action, including investigative steps, criminal charges, or statements for the purpose of affecting any election or for the purpose of giving an advantage or disadvantage to any candidate or political party. Such a purpose is inconsistent with the department's mission and with the principles of federal prosecution. See 9-27.260. Any action likely to raise an issue or the perception of an issue under this provision requires consultation with the Public Integrity section, and such action shall not be taken if the Public Integrity section advises that further consultation is required with the Deputy Attorney General or Attorney General. Justice Manual 9-85.500. See also 9-27.260. Adding the election year sensitivities policy to the principles of federal prosecution. Moving on. Implementation of the election year sensitivities policy can raise challenging questions. Taking action may be viewed as hurting a candidate, while refraining from action may be viewed as helping that candidate. This challenging landscape counsels in favor of structuring and timing investigations in a manner that enables prosecutors and agents to avoid these issues as much as possible and do what they do best: focus on the needs of the case. Consistent with that, Penn often counsels prosecutors to move their investigations along promptly and avoid unnecessary delay that could needlessly place them in the position of deciding whether to take overt action or bring charges in the period immediately before an election. Because of the office's deep familiarity and experience with these policies, it focused on completing both of its investigations promptly and making timely charging decisions long before the election. Subsection 2, Pre-Indictment Procedures. During the investigation and prosecution of this case, the office consulted regularly with Penn. For example, because the election case involved election fraud charges 18 U.S.C. 241 and 371, the office consulted with Penn and its Election Crimes Branch prior to returning the election case indictment in the District of Columbia, as required by Justice Manual 9-85.210, violations of campaign financing laws, federal patronage laws, and corruption of elections consultation requirement. In addition, the office consulted with Penn regarding investigative steps that involved gathering evidence connected to congressional staff pursuant to Justice Manual 9-85.110, investigations involving members of Congress. As discussed below in section V.A.2, the office also consulted Penn regarding issues that arose in litigation involving the speech or debate clause. U.S. Constitution, Article 1, subsection 6, Clause 1, blah, blah, blah. A unique constitutional protection that provides a form of immunity to legislative acts by members of Congress and their staff. See example in repress application for access to judicial records, ancillary to certain grand jury procedures concerning former Vice President Mike Pence. Number 23-MC-35, ECF number 11-5 at 19, DDC June 9th, 2023, referenced above, public release March 27th, 2027 memorandum opinion, application of speech or debate privilege to Vice President when acting as President of the Senate. In resealed case 80 F4 355 DC Circuit 2023. Referenced above, application of speech or debate privilege to search of congressman's cell phone. However, because the office proceeded expeditiously with its investigations and charging decisions, no election year sensitivities consultation with Penn was required prior to returning to the original indictment in either the classified documents case of June 2023 or the election case in August 2023. Subsection 3, Post-Indictment Procedures. The two components of the department's election year sensitivities policy play out differently in the context of post-indictment litigation. First, the bedrock principle that prosecutors may not take any action for the purpose of affecting any election or providing an advantage or disadvantage to any candidate or political party applies fully during post-indictment litigation. On this score, the office did not take a single action at any time for any such purpose. Rather, the office's mission was at all times to uphold the law and carefully follow the requirements of the criminal justice process. Unlike the purpose-focused component of department policy, the component that focuses on the department's reputation for impartiality stands on a different footing with respect to pre-indictment and post-indictment activity. The component of the policy applies fully to the timing of actions by prosecutors prior to indictment, bringing charges, taking overt investigative steps, and making public statements. Justice Manual 9-85.500. For such actions, prosecutors must take election year sensitivities into account, and they are required to consult with Penn. However, once the case is charged, this component of the policy does not limit the ability to litigate according to the schedule set down by the court and does not require consultation with Penn for such litigation. Whether it is during an election year or any other time, the duty of prosecutors after indictment is to litigate their cases fully and zealously, consistent with the Constitution, United States Code, federal rules of criminal procedure, rules of professional responsibility, and dictates of the calendar set forth by the court. See CNN this morning. Garland comments on Trump case, January 19th, 2024. Referenced above, the quote, prosecutor has urged speedy trials, with which I agree, and it's now in the hands of the judicial system, not in our hands, end quote. Once a case is charged, no policy of the department limits the ability of prosecutors to litigate effectively on the schedule set by the court, and that is what the office did. Consistent with the department's policy after the indictment, the office litigated the election case according to the schedule set down by the district court, the D.C. Circuit, and the Supreme Court. Given the gravity of the issues presented by the charges, the office sought to move the case forward expeditiously for two central reasons unrelated to the election. First, the Speedy Trial Act mandates expeditious resolution of criminal charges, and it does so not only for the benefit of the accused, but in the interest of the public. See Zedner v. United States, 547 U.S. 489, 501, 2006. Reference, quote, the Speedy Trial Act was designed with the public interest firmly in mind, end quote. Strunk v. United States, 412 U.S. 434, 439, 1973. Quote, the public interest in a broad sense, as well as the constitutional guarantee, commands prompt disposition of criminal charges, end quote. Cobbledick v. United States, I love that one. 309 U.S. 323, 325, 1940. Quote, encouragement of delay is fatal to the vindication of the criminal law, end quote. Second, those fundamental interests were heightened in this case, which raised matters of utmost gravity, urgency, and national concern, charging the former president with conspiring to thwart the peaceful transfer of power through lies that undermined the democratic process and ultimately fueled a violent attack on the United States Capitol. These criminal charges warranted prompt and fair disposition, and that is what the office sought to achieve. We're just going to ba-bam. Just going to steal that real quick. Make sure we get that for just in case. Make sure we got our stuff we can condense down, our notes. Gotcha. Coming up on an hour in, got a few more hours left. Appreciate you. If you're hanging out or you're in the chat, something like that, feel free to throw something up. If not, and you're just hanging along for the ride, we appreciate you. Hopping right back in. Both during the investigation and after the case was charged, however, Mr. Trump sought to delay the proceedings, taking the position that when the judicial process conflicted with the election campaign, the court should always yield. See ECF number 30 at 11, proposing April 2026 trial date and emphasizing that, quote, no major party presidential candidate has ever been charged while in the middle of a campaign, end quote. ECF number 103 at 20, Mr. Trump's counsel arguing, quote, the easiest solution to all of this is an obvious one, and that is to adjourn the case after the presidential election. That's the solution, end quote. ECF number 242 at 7 through 8. Asking court to reconsider scheduling order, emphasizing that, quote, President Trump is the leading candidate in the presidential election, which is just weeks away, end quote. The courts did not agree. They consistently rejected Mr. Trump's efforts to delay and stop the proceedings. The court's words and actions throughout the litigation reflected their fundamental commitment to the operation of the judicial process, notwithstanding the election campaign. See ECF number 38 at 53. The public has a, quote, the public has a right to a prompt and efficient resolution of this matter, end quote. ECF number 29 at 41. Quote, the fact that the defendant is engaged in a political campaign is not going to allow him any greater or lesser latitude than any defendant in a criminal case, end quote. At 15, quote, And so, what the defendant is currently doing, the fact that he's running a political campaign currently has to yield to the orderly administration of justice, end quote. At 19, quote, I cannot and I will not factor into my decisions the effect it's going to have on a political campaign for either side, end quote. United States v. Trump. Yeah, because if you decide you're not going to do it, that's political as well. Everybody says, oh, yeah, it's political to charge him. No, it'd be political to not charge him, dipshit. United States v. Trump, 88F, 4th, 990, 1018, D.C. Circuit, 2023. Don't know why I can't read. Quote, delaying the trial date until after the election, as Mr. Trump proposes, would be counterproductive, create perverse incentives, and unreasonably burden the justice process, end quote. At 1016, quote, but there is another fundamental constitutional interest at stake here. The existence of a political campaign or political speech does not alter the court's historical commitment or obligation to ensure the fair administration of justice in criminal cases. A trial's participants' engagement in political speech cannot degrade or diminish the essential judicial function. That essential judicial function, end quote. Trump number 23-3228 per curiam order, D.C. Circuit, December 13th, 2023, expediting briefing and oral argument. Trump, same thing, accelerating the schedule for Mr. Trump to seek any further review. Moving on. The office also sought to move the election case forward expeditiously in the Supreme Court based upon the public interest in a prompt resolution of the case and the precedent set by the Watergate Special Prosecutor in United States v. Nixon, 418 U.S. 683, 1974 Nixon, where the court, quote, granted both the United States' petition for we're not even gonna try. We're gonna boom, boom, boom. It's that easy. I hate everything. Woof. We're gonna take a brief break.
Certiorari or certiorari.
Petition for certiorari or certiorari. Okay. Before judgment, number 73-1766. Or 1766. I don't think that's referencing a year. I would doubt it. And also the president's cross petition for the, let's get it again.
Certiorari or certiorari.
There you go. Because of the public importance of the issues presented and the need for their prompt resolution. At 686, 687 citations omitted. The office filed a petition for certiorari before judgment, which would have moved the election case directly to the Supreme Court from the district court and argued that the court should follow the Nixon model. The Supreme Court did not grant the office's petition for certiorari before judgment. However, like the D.C. Circuit, the Supreme Court ultimately expedited its consideration of the case, further confirming the office's emphasis on the strong public interest and prompt resolution. So at every point, they were trying to spur it along, and then Trump was trying to drag it up and then say, oh, yeah, you're trying to get it closer to the election. No, you were literally trying to get it right at the election. You fucking suck. Following the Supreme Court's immunity decision, the office again proceeded in a manner that was fully consistent with the letter and spirit of the department's election year sensitivities policy, litigating the case according to the schedule established by the district court, taking action based upon the law and the best interests of the case, and consulting with Penn. Upon receiving the decision, the office immediately began a multifaceted process to determine the best way forward, including 1. A thorough evaluation of the opinion itself, 2. An exhaustive and detailed review of the evidence and the allegations in the original indictment to determine whether there was sufficient non-immune evidence to support the charge in light of the opinion, 3. Once the office determined that there was sufficient non-immunized evidence, an evaluation of whether to litigate the case based on the existing grand jury record and indictment, or instead seek a superseding indictment that would be presented to a grand jury that had not heard any immunized evidence, and 4. Given the timing, evaluate whether all of the necessary steps could be undertaken consistent with the election year sensitivities policy. The office determined that there was sufficient non-immunized evidence to support the charges, and that the best course of action for the case was to obtain a superseding indictment that implemented the Supreme Court's holding in Trump and present that new indictment to a grand jury that had not heard evidence of immunized conduct. See ECF number 228, Notice of Superseding Indictment. Before doing so, the office consulted Penn for 2 purposes. 1. To obtain Penn's concurrence regarding the proposed election fraud charges under 18 U.S.C. 241 and 371, as required by Justice Manual 9-85.300, and 2. Given the timing of the superseding indictment, to consult with Penn regarding election year sensitivities pursuant to Justice Manual 9-85.500 and the Attorney General's election year sensitivities memorandum. Penn concurred with the return of the superseding indictment, which was returned by the grand jury on August 27, 2024. Following the superseding indictment and consistent with the district court's instructions, on August 30th, 2024, the parties submitted their positions regarding the schedule for pretrial proceedings, ECF number 229. The office proposed that it file an opening brief regarding immunity in which it would provide detailed information without which the court could not undertake the fact-bound analysis that was required by the Supreme Court's remand. The office argued that its filing would include the information that the defense would need to address and that the district court would need to make its immunity determinations regarding both the allegations in the superseding indictment and the evidence that the office would introduce at trial, in a manner that would avoid the prospect of multiple interlocutory appeals. Were the defense to file first on remand, it would leave a large gap in the analysis that the district court was required to undertake, because only the office could identify all of the evidence upon which the charges were based and upon which it would rely at trial. See ECF number 232, 12 to 15, transcript of hearing. The office did not propose a particular date for filing its immunity brief or a schedule for conducting an immunity litigation. The immunity litigation. Don't know why I can't read. It left those matters to the court's discretion. Mr. Trump proposed that the immunity litigation should not begin until December 2024. The district court issued an order setting a new schedule for pretrial litigation and directing the office to file its opening immunity brief on September 26, 2024. Prior to filing its immunity brief, the office again confirmed with Penn that the election year sensitivities policy did not apply to conducting such post-indictment litigation according to the court's schedule, and that the Justice Manual did not require consultation with Penn regarding such litigation. And after the office filed its immunity brief and Mr. Trump attempted to delay its public disclosure, the district court again rejected his attempt to conflate the election and the criminal justice process. Referenced. In addition to the assertions discussed above, defendant's opposition brief repeatedly accuses the government of bad faith partisan bias. See defendant's opposition at 2-5-6. These accusations, for which defendants provide no support, continue a pattern of defense filings focusing on political rhetoric rather than addressing the legal issues at hand. So they're literally saying you're just calling us partisan. You're not arguing the case. See oversized brief order at 2.3 identifying 2 recent instances of this pattern. Not only is that focus unresponsive and unhelpful to the court, but is also unbefitting of experienced defense counsel, and undermining of the judicial proceedings in this case. ECF number 251 at 7. Throughout its work, the office focused entirely on its mandate to uphold the law and nothing more. The career prosecutors in the office conducted its investigation. The career prosecutors in the office conducted its... Oh, okay, I read it wrong. That's my fault. Lols. The career prosecutors in the office conducted its investigation and prosecution in a manner that complied fully with the department's policies regarding election year sensitivities. Followed all the rules. What are you going to do? All right. We are on to volume 5. Volume 5. We are ripping right through it. Remember to like, follow, comment, subscribe, whatever. If you're watching live, we appreciate you. If you watch afterwards, we appreciate you. Everything that's you see here will be uploaded to YouTube after, so tune in. Or if you're watching on YouTube now, really appreciate you. Thank you so much. On with Volume 5. Investigative challenges and litigation issues. In a corruption or a conspiracy investigation, it is not unusual for a subject or target of the investigation to continue to wield significant influence over or command strong loyalty from potential witnesses, often complicating the ability of prosecutors to obtain evidence. That dynamic was amplified in this case given Mr. Trump's political and financial status and the prospect of his future election to the presidency. Yeah, no shit. He can promise you a pardon. As described below, one company resisted a lawful court order issued during the office's investigation, and important witnesses made the choice to assert privileges against providing evidence based on their own official positions in the government. In addition, after his indictment, Mr. Trump used his considerable social media presence to make extrajudicial comments, sometimes of a threatening nature, about the case, and the office was forced to pursue litigation to preserve the integrity of the proceeding and prevent witness intimidation. Mr. Trump was also able to raise claims of executive privilege and presidential immunity. This section discusses each of the challenges and how the office addressed them. So this is Volume 5, Part A, Subsection 1, the Twitter X search warrant. Mr. Trump's public statements, and specifically his post on the social media application Twitter, constituted important potential evidence of his criminal conduct and intent. Accordingly, on January 17, 2023, the office applied for and the district court authorized a search warrant requiring Twitter to provide certain information regarding Mr. Trump's Twitter account. In Twitter search warrant number 23-SC-31. Twitter decision. Excuse me. At the same time, as in common in non-public criminal investigations, to prevent individuals under investigation from destroying evidence or otherwise hampering the process, the office asked the district court to issue a non-disclosure order, an NDO, which would direct Twitter that it could not inform Mr. Trump that the office was seeking information regarding his account. The district court granted the request and issued the NDO. The search warrant required Twitter's compliance within 10 days of its issuance, but the day before that deadline, its senior director of legal informed the office that, quote, it would not comply with the warrant by the next day, end quote. Shortly thereafter, Twitter's senior director of legal Shortly thereafter, Twitter's senior director of legal further informed the office that it would not comply with the warrant, quote, without changes to the NDO, end quote, permitting Twitter to notify Mr. Trump of the warrant. Twitter claimed that the NDO impinged on the First Amendment interests in communicating with the former president, which, according to Twitter, were heightened because the warrant purportedly could implicate issues of executive privilege, though it conceded that it had no standing to raise any privilege issues. The district court later described Twitter's actions as, quote, extraordinary, end quote, and noted that its resistance to the NDO appeared to be a first in the company's history. Quote, for what appears to be the first time in the nearly 17-year existence as a company, Twitter seeks to vacate or modify an order issued under the Stored Communications Act, commanding that the company not disclose the existence of a search warrant for a user's Twitter account, and further seeks to condition any compliance by the company with that search warrant on the user or user's representatives first being notified about the warrant and given opportunity to stop or otherwise intervene in execution of the warrant, end quote. The office promptly moved in district court to have Twitter show cause why it should not be held in contempt of court, asking the district court to impose a penalty that doubled with each day of noncompliance, starting at $50,000. In rejecting Twitter's basis for refusing to comply with the warrant, the district court emphasized that the search warrant and NDO had been, quote, issued by this court after being apprised of extensive reasons sufficient to establish probable cause for issuance of the warrant and to meet the statutory requirements for an NDO, to which reasons Twitter is neither privy nor entitled to be privy, end quote. The district court rejected Twitter's contentions, finding that there existed compelling government interest to maintain the NDO, to preserve the integrity of the investigation, and that as a practical matter, quote, if accepted, Twitter's argument would invite repeated litigation by Twitter and other electronic communication services providers to challenge NDOs in order to alert users, Stored Communications Act, Stored Users to Stored Communications Act orders, particularly for high-profile, highly placed users such as the current and formal government officials with whom providers might want to curry favor with concomitant and inevitable delays in execution of Stored Communications Act orders and resultant frustration in expeditiously conducting criminal investigations, end quote. Hooah, getting through it. The district court ultimately held that the NDO lawfully prohibited Twitter from notifying Mr. Trump about the warrant and fined Twitter $350,000 for failing to comply with the court-ordered search warrant in a timely fashion, finding that Twitter failed to show good faith and substantial compliance in response to the warrant. The sanction and NDO were both upheld by the D.C. Circuit, and Supreme Court declined to review the case. Upholding NDO where the order was narrowly tailored, and, quote, the district court specifically found reason to believe that disclosure of the warrant would jeopardize the criminal investigation, end quote. See also at 836, holding that the, quote, sanction ultimately imposed was not reasonable given Twitter's $40 billion valuation and the court's goal of coercing Twitter's compliance, end quote. So they didn't do enough. Surprise, surprise. So this is volume 5, part A, subsection 2, legislative privilege under the speech or debate clause. All right. The speech or debate clause provides that, quote, for any speech or debate in either house, senators and representatives shall not be questioned in any other place. U.S. Constitution, Article 1-6, Clause 1. The clause affords members of Congress a number of distinct protections, including a testimonial privilege that guarantees that a member, quote, may not be made to answer, quote, questions about his or her legislative acts. Gravel v. United States, 408 U.S. 606, 616, 1972. During the investigation, former Vice President Pence in his capacity as president of the Senate, invoked his privilege under the speech and debate clause. Through litigation over the scope and applicability of the claimed privilege, the office obtained important evidence. After the grand jury subpoenaed Mr. Pence to testify about Mr. Trump's alleged efforts to overturn the results of the 2020 election, Mr. Pence moved to quash the subpoena, invoking the speech and debate clause. Mr. Pence argued that the vice president should receive the protections of the speech and debate clause when acting in his constitutional capacity as president of the Senate, as he did while presiding over the joint session of Congress on January 6, 2021. According to Mr. Pence, the speech and debate clause therefore foreclosed questioning before the grand jury about his legislative acts relating to the joint session. The Chief Judge of the United States District Court for the District of Columbia, who presides over grand jury matters in that district, denied, quote, in large part, end quote, Mr. Pence's motion to quash. The court held, quote, that while the clause does apply to the vice president, it does not cover the vast majority of what the special counsel seeks to ask him about, end quote. The court determined that although the speech and debate clause foreclosed questioning about Mr. Pence's legislative acts, much of the conduct the office sought to question Mr. Pence about did not qualify as legislative acts under the speech and debate clause, including, for example, Mr. Trump's, quote, conversations exhorting Pence to reject electors on January 6, end quote. The court concluded that the speech and debate clause precluded government questioning in two subject areas. One, Mr. Pence's drafting and recitation of the statement he made on the floor of the Senate on January 6th, and two, internal advice from Mr. Pence's staff about the scope of his authority on January 6th. Neither the office nor Mr. Pence appealed the district court's decision, so they agreed with that. Volume 5, Part B. Part B, that's what that means, apparently. Threats and harassment of witnesses. A significant challenge that the office faced after Mr. Trump's indictment was his ability and willingness to use his influence and following on social media to target witnesses, courts, and department employees, which required the office to engage in time-consuming litigation to protect witnesses from threats and harassment, which was, of course, the goal. Slow them down any way you can. Mr. Trump's resort to intimidation and harassment during the investigation was not new, as demonstrated by his actions during the charged conspiracies. A fundamental component of Mr. Trump's conduct underlying the charges in the election case was his pattern of using social media, at the time Twitter, to publicly attack and seek to influence state and federal officials, judges, and election workers who refused to support false claims that the election had been stolen or who otherwise resisted complicity in Mr. Trump's scheme. After Mr. Trump publicly assailed these individuals, threats and harassment from his followers inevitably followed. See ECF number 57 at 3. One witness identifying Mr. Trump's tweets about him as the cause of specific and graphic threats about his family, and a public official providing testimony that after Mr. Trump's tweets, he required additional police protection. In the context of the attack on the Capitol on January 6th, Mr. Trump acknowledged that his supporters, quote, listened to him like no one else, end quote. The same pattern transpired after Mr. Trump's indictment in the election case. As the D.C. Circuit later found, Mr. Trump, quote, repeatedly attacked those involved in the case through threatening public statements, as well as messaging daggered at likely witnesses. Daggered, I haven't heard that, like aimed, I guess. As well as messaging daggered at likely witnesses and their testimony. Trump, 88 F 4th at 1010. Those attacks had, quote, real-time, real-world consequences, end quote, exposing, quote, those on the receiving end, quote, end quote, a torrent of threats and intimidation, end quote, and turning their lives, quote, upside down, end quote. The day after his arraignment, for example, Mr. Trump posted on social media application Truth Social, quote, if you go after me, I'm coming after you, end quote. The next day, quote, one of his supporters called the district court judge's chambers and said, hey, quote, hey, you stupid, and blank, blank, bunch of cuss words. If Trump doesn't get elected in 2024, we are coming to kill you, so tread lightly. Lols. You'll be targeted personally, publicly, your family, all of it, end quote. Mr. Trump also, quote, took aim at potential witnesses named in the indictment and, quote, lashed out at government officials closely involved in the criminal proceeding, end quote, as well as members of their families. To protect the integrity of proceedings, on September 5th, 2023, the office filed a motion seeking an order pursuant to the district court's rules restricting certain out-of-court statements by either party. The district court heard argument and granted the office's motion, finding that Mr. Trump's public attacks, quote, pose a significant and immediate risk that, one, witnesses will be intimidated or otherwise unduly influenced by the prospect of being themselves targeted for harassment and threats, and two, attorneys, public servants, and other court staff will themselves become targets for threats and harassment, end quote. Because no, quote, alternative means, end quote, could adequately address these, quote, grave threats to the integrity of these proceedings, end quote, the court prohibited the parties and their counsel from making the public statements that, quote, that, quote, target, one, the special counsel prosecuting this case or his staff, two, defense counsel or their staff, three, any of this court staff or other supporting personnel, or four, any reasonably foreseeable witness or substance of their testimony. Pretty sweeping, pretty broad. The court emphasized, however, that Mr. Trump remained free to make, quote, statements criticizing the government generally, including the current administration or the Department of Justice, statements asserting that he is innocent of the charges against him, or that his prosecution is politically motivated, or statements criticizing the campaign platforms or policies of his current political rivals, end quote. So he's still free to say a whole bunch of stuff, never silenced him. You just can't call out these people specifically because we don't want you tampering with the case. You can't tamper with the witnesses. You can't tamper with the people that are doing it, not the courts, not the prosecution. Pretty fucking simple. Or so you would think. Mr. Trump appealed, and the D.C. District Court affirmed in large part, finding that Mr. Trump's attacks on witnesses in the case posed, quote, a significant and imminent threat to individuals' willingness to participate fully and candidly in the process, to the content of their testimony and evidence, and to the trial's essential truth-finding function, quote, end quote, with, quote, the undertow generated by such statements, end quote, likely to, quote, influence other witnesses, end quote, and deter those, quote, not yet publicly identified, so it scares other people, that's true, end quote, out of, quote, fear that if they come forward, they may well be the next target. It's very true. If you punish the people that are out there now, who's going to stand up? Pretty scary stuff. Love to see it. Likewise, quote, certain speech about counsel and staff working on the case poses a significant and imminent risk of impeding the adjudication of the case, end quote, since, quote, messages designed to generate alarm and dread and to trigger extraordinary safety precautions will necessarily hinder the trial process and slow the administration of justice, end quote. So you're just wasting the court's resources because you're threatening the court staff and shit. Don't do that. The Court of Appeals explained that the district court's order, quote, involved the confluence of two paramount constitutional interests: the freedom of speech guaranteed by the First Amendment and the federal court's vital Article III duty to ensure the fair and orderly administration of justice in criminal cases. Balancing these interests, the court explained, required consideration of three related questions. Quote, 1, whether the order is justified by a sufficiently serious risk of prejudice to an ongoing judicial proceeding. 2, whether less restrictive alternatives would adequately address the risk. And 3, whether the order is narrowly tailored, including whether the order effectively addresses the potential prejudice, end quote. Because, quote, the record amply supported, end quote, the district court's finding that, quote, when Mr. Trump has publicly attacked individuals, including on matters related to this case, those individuals are consequently threatened and harassed, end quote. and because, quote, no less speech restrictive alternative could viably protect against the imminent threat to the participation of witnesses, trial participants, and staff in this criminal matter, or the full, fair, and unobstructed receipt of relevant evidence, end quote. The court affirmed the decision to, quote, impose some limitation on trial participants' speech, end quote. Indeed, quote, given the record in this case, the district court had a duty to act proactively to prevent the creation of an atmosphere of fear or intimidation aimed at preventing trial participants and staff from performing their functions within the trial process, end quote. The Court of Appeals therefore affirmed the district court's order to the extent that it prohibited parties and their counsel from making, quote, public statements about known or reasonably foreseeable witnesses concerning their potential participation in the investigation or in this criminal proceeding, end quote. Or, quote, public statements about, one, counsel in the case other than the special counsel, two, members of the court staff and counsel staff, or three, family members of any counsel or staff member, if those statements are made with the intent to materially interfere with or to cause others to materially interfere with counsel's or staff's work in this criminal case, or with knowledge that such interference is highly likely to result, end quote. To ensure that going forward, the order was as narrowly tailored as possible, the court vacated the district court order, quote, to the extent it covered speech beyond those specified categories, end quote. All right. Ripping through. We made it to part C, and I believe we are in volume 5. This is Mr. Trump's claims of executive privilege. Whoa. Definitely got a little bit more gas left in the tank, so we'll keep going for a little bit, but I'm probably going to hop on and play some games here before too long. Just to mix it up and make sure I don't lose my mind. But make sure you tune in if you like what you see, or if you want to see something different, tune on. I'm on all the major ones, so Twitch, YouTube, also Patreon. You can catch me on Twitter, all the good stuff. So make sure you tune in all the different places to come check it out. We are keeping pushing right through. Like I said, this is volume 5 of the Jack Smith Report. This is part C, Mr. Trump's claims of executive privilege. As you can tell, my mouth and my tongue are getting tired. Not really worth anything. So, ooh, here's a good. This is a good. We're just gonna take a quick little breaky poo. To this. And so you can still hear me, but can't see me. All good. Whew. We are just gonna take one little quick break, and then we're gonna hop right back into it. Probably trying to push through all of C, and then we'll see how we're feeling. But if the quality of my reading goes down, I like to cut it off before it gets too bad, so that way it can be even. So we're going to take a break here. We're about a little over an hour way in, so good time for a little break, and then we will hop back in, keep plugging away at that part C, and then the idea being to finish just as much as we can today, and then hop back in sometime during the week, maybe finish this. We also want to look at the judge stayed the order. There's a restraining order for the the change to the amendment, the denaturalization, stuff like that. What I'd love to get into as we start, getting past this and into other stuff, it'll be fun to review stuff, maybe go over, do some React content to some videos. Might be a lot of fun. So if you want to see more stuff like that, if you want to see less of this and more of that, more of the React stuff, definitely follow along, comment, let me know what you want. Until then, we're just going to go over what I think is important. It's 4:20 somewhere, right? All right. Right back into it. Ain't nothing changed but the weather. Hopping right in. A time-consuming investigative challenge that the office faced was Mr. Trump's broad invocation of executive privilege to try to prevent witnesses from providing evidence on a wide variety of topics. Mr. Trump asserted a form of executive privilege known as the Presidential Communications Privilege, a special privilege belonging to presidents that the Supreme Court has found derives from the Constitution's design of the executive branch and the separation of powers. Ooh, see a whole bunch of Nixon president and a bunch of stuff with respect to 14 executive branch officials. Just not even going to go through that. If you want to, you can. Mr. Trump's repeated assertion of the presidential communications privilege as a basis to withhold evidence required extensive pre-indictment litigation that delayed the office's receipt of important testimony and other evidence, including testimony from senior White House staff and executive branch officials about topics such as Mr. Trump's knowledge that he had lost the election and the pressure campaign Mr. Trump waged against the vice president to convince him to reject legitimate elector slates at the January 6th certification proceeding. The courts uniformly rejected Mr. Trump's privilege assertions, seeking to deny the grand jury from hearing evidence from executive employees. See a whole bunch of memorandum, opinion, blah, 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 precedent, blah, blah, blah. Finding that evidence was, quote, directly relevant, important, and essential, end quote, to the office's investigation, as well as unavailable elsewhere. So they couldn't find what they needed, and they were stalling as much as they can, the Trumples. In each instance, the courts determined that, quote, importance and unavailability, end quote, of that, quote, vital, end quote, evidence, quote, outweighed, end quote, the qualified privilege for presidential communications and ordered that it be produced promptly to the grand jury. And when Mr. Trump tried to delay the investigation even further by seeking to stay orders denying his executive privilege claims pending appeal, district and appellate courts rejected all of them. In doing so, one court held that Mr. Trump was engaging in an, quote, obvious, end quote, effort to delay the investigation and impede the grand jury from carrying out its constitutional responsibilities, and separately observed that staying proceedings risked indefinite delay. Memorandum opinion, December 18th, 2022, reference, quote, the court thus declines to further pause the grand jury's constitutionally protected work, particularly in the absence of any reassurance that the former president's delay tactics will cease, end quote. So we're not going to give you this one because you're literally just stalling for no other reason than to stall. So why the fuck would we stall it now for no reason and then give you more time? Why wouldn't you just stall it then for no reason? It just doesn't make sense. It's like talking to a child. That's literally what you're dealing with. Another court concluded that Mr. Trump's claim that the impact of delay on the investigation would be, quote, nominal, end quote, was a, quote, vast understatement, end quote, noting that instead it quote, would be serious and deleterious, end quote, and would, quote, harm the public interest, end quote. Hearing transcript, April 2023. Moving on. The presidential communications privilege covers evidence, quote, that reflects presidential decision-making and deliberations that the president believes should remain confidential, end quote. The law on the presidential communications privilege derives from the Supreme Court's decision in Nixon. There, the court recognized a, quote, presumptive privilege for presidential communications, end quote, which it described as, quote, fundamental to the operation of government and inextricably rooted in the separation of powers under the Constitution, end quote, 418 U.S. at 708. But the court held that the privilege is qualified, not absolute, at 706, 707, emphasizing, quote, our historic commitment to the rule of law, end quote, which is, quote, nowhere more profoundly manifest than in our view that the twofold aim of criminal justice is that guilt shall not escape or innocence suffer. I'm just gonna snag that. See if the Supreme Court feels it lived up to that. Specifically, the court, quote, weighed the importance of the general privilege of confidentiality of presidential communications in performance of the president's responsibilities against the inroads of such privilege on the fair administration of criminal justice, end quote. And it concluded that, quote, the generalized assertion of privilege must yield to the demonstrated specific need for evidence in a pending criminal trial, end quote. The D.C. Circuit has applied the same general standard to grand jury subpoenas. Moving on. Most of the executive privilege litigation in the case took place in 5 sealed proceedings between August 2022 and March 2023, concerning the testimony of 14 witnesses in total. See Media Access ECF number 32, notice attaching district court orders and memorandum opinions. In August 2022, before the special counsel was appointed, the government began to seek evidence from 2 former executive branch employees of Mr. Trump's, including by issuing subpoenas for testimony before the grand jury. Although the government believed it unlikely that the information that it sought from these witnesses was subject to the presidential communications privilege because it did not concern presidential decision-making, in an abundance of caution, given the unprecedented circumstance of the investigating the former president, the government made certain notifications to determine whether executive privilege would be a contested issue. Specifically, with the district court's permission, the government notified Mr. Trump and the incumbent president about the subpoenas to ascertain whether either would assert executive privilege or identified certain potential topics of investigative inquiry. The government chose to notify both the sitting and former presidents, even though it was unsettled under GSA whether a former president's view about potential harm to executive branch confidentiality interests could supersede the sitting presidents. See GSA 433 U.S. at 449. The incumbent president responded through the White House counsel's office that he did not intend to insert executive privilege. Mr. Trump instructed the 2 witnesses that they should not provide testimony about any privileged communications, and he specifically identified the presidential communications privilege. See Media Access ECF number 32-2 at 9 and 10. After the witnesses withheld testimony pursuant to Mr. Trump's instructions, the government filed a motion to compel with the Chief Judge of the United States District Court of the District of Columbia. Given that the investigation focused largely on Mr. Trump's activities as a candidate seeking office, not his official activities as president, the government believed that it was likely that many, if not all, the communications at issue were not subject to presidential communications privilege because they were not made in the process of arriving at presidential decisions. That is a good one. Boom, boom, boom. Make sure we get this while we rip through it, because that's definitely one of the ones that's brought up. a decent bit, is whether or not he was acting in some official capacity or not. And it's just so clear, if you're looking at it honestly, that he's not. But what are you gonna do? Couldn't prove it in court, so couldn't prove it in the eyes of the public either. So all we have is the report now. As the Supreme Court has explained, the presidential communications privilege, quote, is limited to communications in performance of a president's responsibilities of his office and made in the process of shaping policies and making decisions, end quote. GSA 433 U.S. at 449. Citations, quotations, and alterations omitted. But the government's position was that the district court did not have to decide whether the communications at issue were subject to the privilege, and instead could assume that the communications were privileged and find that the government had overcome any privilege that would apply to presidential communications because it had made the showing of need for evidence that required under Nixon, the evidence required under Nixon. Under D.C. Circuit precedent, to make the required showing of need, the government had to establish that the testimony withheld by the witnesses likely contained important evidence that was not available to the grand jury with due diligence elsewhere. So you couldn't get it anywhere else. So that's how they're getting past that. They're overcoming the showing of need by showing that you can't get it anywhere else. We have to breach this veil because you can't get the information elsewhere. After briefing and argument, the district court granted the government's motion to compel. The court found that the witnesses possessed, quote, unique and inimitable evidence, end quote, Media Access ECF number 32-2 at 28 and 29, that was, quote, important and relevant to the grand jury's investigation, end quote. The court concluded that the witnesses possessed, quote, vital evidence for the grand jury, the importance and unavailability of which outweigh the presidential communications privilege in this case, end quote. The district court subsequently denied a motion by Mr. Trump for a stay pending appeal. So get the fuck out of here with that shit. The Court of Appeals also denied a stay pending appeal and later dismissed the appeal as moot. In the following months, the government filed 2 more motions to compel testimony from 3 additional witnesses. The district court granted the motions, making findings with respect to each witness that the government had made a showing of need to overcome the qualified privilege for presidential communications, not presidential immunity. The district court also denied stays of pending appeals. So you can't delay it pending the appeal. Whole bunch of that. Whole bunch of trying to delay. What's new? After the appointment of the special counsel, it became clear, given the scope of the grand jury's investigation and the need to obtain evidence from a number of former executive branch officials, that seeking to compel testimony from 1 or 2 witnesses at a time would be inefficient and would unduly delay the investigation. The office therefore decided to consolidate the proceedings to the extent possible and filed 2 additional motions to compel that covered the remaining 8 executive branch officials who had communicated through their attorneys that they would withhold testimony from the grand jury based on executive privilege. The district court granted the motions, making findings with respect to each individual witness that, as noted above, they, quote, possessed vital evidence for the grand jury, the importance and unavailability of which outweighed the presidential communications privilege, end quote. The district court also denied stays pending appeals. Subsequently, the Court of Appeals denied stays pending appeals in both cases, dismissed one of the appeals as moot, and granted Mr. Trump's motion to voluntarily dismiss the other appeal. This is part D. And then it looks like D has a couple subsections. Okay, D is long. D might be where we stop, and then you get down to the conclusion. No, we're going to push through it. We're going to finish it today. This is going to be final part. It's going to take a bit, but we're going to do it. We're here. We got it. Part D. Whew. This is presidential immunity that we're getting into. There's going to be a couple parts, and then we will get to the conclusion today. We're going to push right on through. So if you want to see the conclusion of our coverage on the Jack Smith report, or at least the conclusion of reading through, we have our notes on it now, so anybody that wants to talk about it, anything like that. And then I've been sparring with some crazy people on Twitter and stuff like that, so hopefully we'll get some conversations here soon. I'm hoping to have some more reasonable conversations. I'm kind of stalling a little bit, just taking a break from reading. Believe it or not, there's not a terrible amount left to go through. Where's the conclusion? Yeah. Okay. So we got like 14 pages, 14, 15 pages. Nothing crazy. This is the for ending the stream abruptly the other day and hopping off. We're just gonna hop on and we're just gonna finish it because we have part 3 up. This is part 4, so we got everything we need. It'll be final part is what we'll put on the YouTube video, but that'll be a fun one to push to. And then if we have questions about anything, we took down some of the case precedent and stuff like this. We might go through the Nixon case again, especially if we have time. But we got a couple other things that we're trying to get through. So we'll work everything in as we can. Here we are. This is Volume 5, Part D, Presidential Immunity. So this is going to be a fun one. I'm guessing this is going to talk about everything after the Supreme Court decision came down. Before this case, no court had ever found that presidents are immune from criminal responsibility for their official acts, and no text in the Constitution explicitly confers such criminal immunity on the president. Gotta love that. I'm just gonna boom. Just like the way things are worded here, you know, got a good way of wording things. As set forth below, prior criminal investigations by the Department of Justice, whether conducted through special prosecutors, independent counsels, or special counsels, had examined whether presidents had violated federal criminal law through use of their official powers, and none of those investigations had regarded former presidents as immune from criminal liability for their official acts. The office proceeded from the same premise. It's just like, hey, we were starting on the same planet as you were, right? Apparently not. Soon after the original indictment issued in the election case, Mr. Trump raised a claim of immunity in a motion to dismiss the indictment. The district court denied the immunity motion, and the Court of Appeals affirmed. The Supreme Court, however, vacated the Court of Appeals judgment based on its conclusion that presidents have absolute immunity for core official conduct that Congress lacks power to regulate, at least presumptive immunity for official presidential acts, and no immunity for unofficial conduct. We're just going to take that whole tidbit of American history and throw it right there in the Jack Smith part. The court then applied that test to hold that certain conduct alleged in the indictment was immune, while remanding for application of its legal framework to the remaining allegations. So they said certain stuff was immune, so they went in and they picked specific stuff and then remanded other stuff of its legal framework to the remaining allegations. Blah, 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 blah. Trump 603 U.S. at 593. That's a whole court case. We could do a whole other one on that, and we might pull up, or at least the dissenting opinions. That might be fun. The office responded by obtaining a superseding indictment to comply with the court's decision and by seeking district court rulings that charged conduct and expected evidence at trial was not shielded by immunity. This section summarizes the chronology of the immunity litigation and key findings of the courts throughout. Because the immunity litigation unfolded on the public record, this discussion provides an overview. The office's briefs and judicial decisions contain more detailed analysis. Subsection 1. Prosecutorial decisions during the charging stage. The office conducted its investigation against the background of the department's prior legal determinations with respect to the potential criminal liability of a former president for official acts. The long-standing view of the department was that the Constitution's separation of powers precludes prosecution of a sitting president for official or unofficial acts. See memorandum from Randolph D. Moss, Assistant Attorney General, Office of Legal Counsel, a sitting president's amenability to indictment and criminal prosecution, October 16th, 2000. Memorandum from Robert G. Dixon, Assistant Attorney General, Office of Legal Counsel, amenability of President, Vice President, other legal officers to federal criminal prosecution while in office, But that same legal conclusion recognizes that former presidents could be held criminally liable for conduct undertaken while in office. 2000 OLC opinion at 255 and number 32-257, the department's constitutional analysis of the, quote, temporary, end quote, immunity of a sitting president drew no distinction between official acts and unofficial conduct. So they say in that same one that you could say, oh yeah, you can't charge a sitting president, and that same one they say, yeah, well, after you're gone, there's no immunity for official acts or unofficial conduct or whatever the fuck the Supreme Court is talking about. There's just no basis for that Supreme Court decision whatsoever. It's dog shit. Consistent with that analysis, former Department of Justice prosecutors had historically investigated presidential conduct based on the understanding that no criminal immunity would bar prosecution if the president had used his official powers to violate federal criminal law. Significantly, no president whose conduct was investigated, other than Mr. Trump, ever claimed absolute criminal immunity for all official acts. During the Watergate investigation, for example, prosecutors examined whether President Nixon was liable for the obstruction of justice conspiracy charged against the Watergate conspirators. Although President Nixon was not indicted, the grand jury named him as a co-conspirator, United States v. Nixon. I'm just going to It's just so normal. You just would charge him. That's just like what you would do. And in the Supreme Court, President Nixon acknowledged his exposure to prosecution after leaving office. Like he literally, it's so frustrating. It's so frustrating. He knew he could be charged. It's like a thing. They know. Referenced, quote, while out of necessity, an incumbent president must not be subject to indictment in order for our constitutional system to operate, he is not removed from the sanction of the law. He can be indicted after he leaves office at the end of his term or after being, quote, convicted, end quote, by the Senate in an impeachment proceeding. So it says both right there. It's not after he leaves office at the end of his term or after being convicted. You don't need to be impeached first. There's just so many arguments that are dog shit. Similarly, President Ford's pardon of President Nixon rested on both presidents' understanding that President Nixon was exposed to criminal liability. See Trump v. United States, bunch of precedent, collecting sources. Later, independent counsel Lawrence Walsh and special counsel Robert S. Mueller conducted investigations into presidential conduct. Lawrence Walsh, final report of the Independent Counsel for Iran-Contra Matters, investigation into prosecutions. Robert Mueller, report on the investigation into Russian interference in the 2016 presidential election, March 2019, aka the Mueller report. Neither investigation reflected the view that presidents, after leaving office, were immune from prosecution for their official acts. See Mueller report at 168 to 181, analyzing constitutional separation of powers issues and statutory clear statement issues before concluding that that didn't make sense the way I was reading it, sorry. that the president was not categorically exempt from criminal law for his official acts. Quoting the Walsh Report, quote, a past president, end quote, can be, quote, subject to prosecution in appropriate cases, end quote. And counsel for former President Trump stated at his second Senate impeachment trial that declining to convict him on the article of impeachment alleging conduct related to January 6th would not place him in, quote, any way above the law, end quote, because a former president, quote, is like any other citizen and can be tried in a court of law, end quote. To proceedings of the U.S. Senate in impeachment trial of Donald J. Trump. So that's them arguing. That's them when I say they want to have their cake and eat it too, they want to have it both ways. This is what I mean. So they argued in front, like when they had the impeachment trial, it's like, oh, you can go ahead and not impeach him. Like if you were feeling bad, if you're a Republican and you were thinking about impeaching him because these things are so bad and you're thinking about crossing the party line, don't worry about it. We'll still charge him later. There'll still be a criminal trial and he'll be subject to that. So you don't have to impeach him. Go ahead and do this. Just like, you don't worry about it. Kick the can down the road. And then when they landed in front of there, so didn't get impeached because they were like, oh, well, we're going to try him afterwards. And then when they went to try him afterwards, they used the argument that, oh, well, you didn't impeach us, so now you can't try it. Like, it's a bunch of bullshit. These people have no principle. That's the funniest thing about it. So a bunch of precedent, and then referenced, quote, the text of the Constitution makes very clear that a former president is subject to criminal sanction after his presidency for any illegal acts that he commits, end quote. This office made its investigative and prosecutorial decisions based on the same understanding. The conduct at issue in the election case involved both unofficial and official conduct. Much of the former president's alleged conduct involved actions in his private capacity as a defeated candidate for re-election seeking to overturn the result. For example, his coordinated conduct with personal attorneys, campaign staff, and other private advisors, such private conduct does not implicate constitutional functions of the presidency. Other alleged conduct, however, did involve the former president's misuse of official authority, including using the power of the presidency directly by exercising his authority over agencies and personnel in the executive branch. In determining to bring charges in the election case, the office therefore examined the former president's amenability to prosecution for that conduct through the lens of two doctrines: the separation of powers under the Constitution and clear statement principles that limit the application of criminal statutes to presidential conduct in certain circumstances. The office concluded that neither the separation of powers nor clear statement principles barred prosecution for the limited instances of official conduct at issue. The determination was consistent with similar conclusions reached by Special Counsel Mueller, by Special Counsel Mueller after detailed constitutional and statutory analysis. His report concluded that, quote, Congress can validly regulate the president's exercise of official duties to prohibit actions motivated by a corrupt purpose, end quote. And that clear statement principles of statutory interpretation did not apply to preclude application of criminal obstruction statutes to corrupt presidential conduct. Mueller report at 168 to 181. Based on the same principles and legal frameworks, the office's analysis determined that the potential charges, conspiracy to defraud the United States, conspiracy and substantive obstruction of justice offenses, and conspiracy to deprive citizens of voting rights, would not entail application of the statutes in a manner that burdened presidential prerogatives, and thus that the application of criminal law triggered neither clear statement principles nor separation of power concerns. Subsection 2. Immunity litigation. On October 5th, 2023, Mr. Trump filed a motion to dismiss the indictment based on a sweeping claim of presidential immunity for all official conduct during his presidency. After briefing on December 1st, 2023, the district court rejected Mr. Trump's claims of immunity, concluding that, quote, the Constitution's text, structure, and history, quote, do not support the contention that the president is absolutely immune from prosecution of criminal acts performed within his official responsibilities, and that, quote, no court or any other branch of government has ever accepted, end quote, such a contention. Get fucked, nerd. Sorry. It all turned the other way, but that's the type of language this garbage should be met with. The court held that a former president, quote, may be subject to federal investigation, indictment, prosecution, conviction, and punishment for any criminal acts undertaken while in office, end quote. That, quote, exempting former presidents from the ordinary operation of the criminal justice system, end quote, would, quote, undermine the foundation of the rule of law, end quote. And that Mr. Trump's, quote, 4-year service as commander-in-chief did not bestow upon him the divine right of kings to evade the criminal responsibility that governs his fellow citizens, end quote. You're not a king. That's the type of language we need. The district court reasoned that the prospect of federal criminal liability for a former president did not impair the executive's ability to perform its constitutionally mandated functions, quote, either by imposing unacceptable risks of vexatious litigation or otherwise chilling the executive's decision-making process, end quote, and that, quote, it is likely that a president who knows that their actions may one day be held to criminal account will be motivated to take greater care that the laws are faithfully executed, end quote. Absolutely. With respect to the possible chilling effect that criminal liability might have on a president, the court concluded that, quote, the possibility of future criminal liability might encourage the kind of sober reflection that would reinforce rather than defeat important constitutional values. If the specter of subsequent prosecution encourages a sitting president to reconsider before deciding to act with criminal intent, that is a benefit, not a defect, end quote. Mr. Trump appealed the district court's ruling. The D.C. Circuit heard oral argument on January 9th, 2024. In a telling exchange, counsel for Mr. Trump acknowledged that under his theory of immunity, a president could not be criminally prosecuted for ordering SEAL Team 6 to assassinate a political rival unless Congress had first impeached and convicted that president of the same conduct. Which we've already seen. Nobody will impeach anybody because everybody sucks. Less than a month after argument, the Court Appeals affirmed the district court's decision stating, quote, we cannot accept that the office of the presidency places its former occupants above the law for all time thereafter, end quote. In a unanimous opinion, the court stated that, quote, our analysis is, quote, guided by the Constitution, federal statutes, and history, end quote, and that, inside a quote, as well as, inside a quote, concerns of public policy, end all quote, quoting Nixon and Fitzgerald. Quote, relying on these sources, end quote, the court rejected each of Mr. Trump's, quote, potential bases for immunity, both as a categorical defense to federal criminal prosecutions of former presidents and as applied to this case in particular. With respect to the case before it, the court stated that, quote, former President Trump's alleged efforts to remain in power despite losing the 2020 election were, if proven, an unprecedented assault on the structure of our government, end quote. As such, it, quote, would be a striking paradox if the president, who alone is vested with the constitutional duty to, in another quote, take care that the laws be faithfully executed, and that quote, were the sole officer capable of defying those laws with impunity, end quote. It just doesn't make sense, yeah. We're just going to rip all the stuff we like, we're just ripping into the notes. And that's quoting the U.S. Constitution, Article 2, 3, Clause 1. Like the district court, the Court of Appeals found that, quote, the risk of criminal liability chilling presidential action appears to be low, end quote, and that, quote, instead of inhibiting the president's lawful discretionary action, the prospect of federal criminal liability might serve as a structural benefit to deter possible abuses of power and criminal behavior, end quote. Citing with approval the district court's observation that, quote, every president will face difficult decisions. Whether to intentionally commit a federal crime should not be one of them, end quote. Based on the safeguards in place to prevent baseless indictments applicable to all citizens, the court similarly found that, quote, that the risk that former presidents will be unduly harassed by meritless criminal prosecutions appears slight, end quote. So the risk of leaving them open to the liability is slight, and the risk of not having any criminal liability pretty dangerous. More broadly, the court appeals evaluation of our system of separated powers led it to conclude, quote, that there is no functional justification for immunizing former presidents from federal prosecution in general or for immunizing former President Trump from the specific charges in the indictment, end quote. Because it concluded that Mr. Trump did not have immunity for the crimes or conduct charged in the case, the Court of Appeals did not decide whether every allegation in the indictment constituted an official act. However, the court noted that, quote, because the president has no official role in the certification of the Electoral College vote, much of the misconduct alleged in the indictment reasonably can be viewed as that of an office seeker, including allegedly organizing alternate slates of electors and attempting to pressure the vice president and members of Congress to accept those electors in the certification proceeding. The court therefore found it quote, doubtful that all 5 types of conduct alleged in the indictment constitutes official acts, end quote. So, court found it doubtful. That's their way of saying they don't believe you. In a divided decision, the Supreme Court vacated the Court of Appeals judgment and remanded the case for further proceedings. Trump 603 U.S. at 642. The Supreme Court weighed the competing constitutional considerations differently than the lower courts. While the lower courts and the dissenting justices placed greater emphasis on the rule of law considerations, the majority found that the need for presidents to act, quote, boldly and fearlessly, end quote, in executing their duties of office was of paramount importance. So this is the spot where John Roberts, Alito, and all them, they want your executive to be bold and fearless. I say, and a lot of us citizens say, we have more of an interest in not having someone who can commit crimes. The strongest position in our government, being able to commit crimes with impunity, might be slightly more important than you thinking your orange guy can be bold and fearless. You fucking traitors. The court reasoned that there, quote, exists the greatest public interest, and one single quote, in providing the president with, start another quote, the maximum ability to deal fearlessly and impartially with the duties of his office, end those quotes. Start another quote, free from undue pressures and distortions, end quote. The court found that, quote, criminally prosecuting a president for official conduct undoubtedly poses a far greater threat of intrusion on the authority and functions of the executive branch than simply seeking evidence in his possession, end quote. And that the threat of a criminal prosecution was, quote, plainly more likely to distort presidential decision-making, end quote, than a civil suit. In responding to the dissenting justices' concerns that the vast immunity that the court provided opened the door to lawless behavior by presidents in violation of their duty to faithfully execute the law, the court assessed that a president who uses official power to violate the law was a less likely God, it's so goofy. While I'm reading it, you're catching it first time, no pre-read. This is just a wild thing. Ugh. The court assessed that a president who uses official power to violate the law was a less likely, quote, prospect, end quote, than, quote, an executive branch that cannibalizes itself with each successive president free to prosecute his predecessors, yet unable to boldly and fearlessly carry out his duties for fear that he may be next, end quote. So the whole thing was, you don't want to have prosecutions of the last guy. You want to set this up because you don't want them to have them going after the last guy. What has Trump said all about the Biden crime family and all this stuff, and about going after Biden for this, that, and the other? Maybe he's not going to do it. Maybe whatever. I mean, he can't now because they're immune. But he's talked about, like, you didn't get anything. You didn't achieve anything, and you gave away everything. Fucking idiots. The court rejected the lower court's view that the established safeguards, such as the Department of Justice's, quote, longstanding commitment to the impartial enforcement of law, end quote, a neutral grand jury, the requirement in criminal law that the government must prove its case beyond a reasonable doubt, courts enforcing, quote, existing principles of statutory construction and as applied constitutional challenges, end quote. And certain president-specific defenses like the, quote, public authority defense or the advice of the Attorney General, end quote, would adequately protect a former president charged with criminal wrongdoing. Instead, the court placed greater weight on the risk to the administration of government from excessive caution by a president who might face criminal accountability for official acts, reasoning that, quote, without immunity, such types of prosecutions of ex-presidents, end quote, for example, over claims of insufficient enforcement of federal law, quote, could quickly become routine, end quote, thus, quote, enfeebling, end quote, the presidency through, quote, such a cycle of factional strife, end quote. In conducting its balancing, the majority placed greater weight than did the dissents or the lower courts on the importance of protecting independence and fearlessness of the president, as opposed to the risk that immunity would encourage lawless behavior. Contrast at 614, quote, such an immunity is required to safeguard the independence and effective functioning of the executive branch and to enable the president to carry out his constitutional duties without undue caution, end quote. Continuing the quote, the risks of chilling presidential action or permitting meritless, harassing prosecutions are unlikely, unsupported by history, and, quote, too remote and too shadowy to shape the course of justice, end quote, citing Clark v. United States, 1933. More precedent, quote, consequently, to the extent that there are cognizable, and another quote, chilling effects on presidential decision-making from the prospect of criminal liability, they raise far lesser concerns than those discussed in the civil context of Fitzgerald. Every president will face difficult decisions. Whether to intentionally commit a federal crime should not be one of them, end quote. Ultimately, the Supreme Court ruled that for official powers entrusted exclusively to the president, a president is entitled to absolute criminal immunity, and that for other acts, quote, within the outer perimeter of his official responsibility, end quote, he is entitled to at least presumptive immunity. Specifically, the court divided presidential acts into three categories. 1, core presidential conduct that Congress has no power to regulate and for which a former president has absolute immunity. 2, other official presidential acts for which the president has at least presumptive immunity. And 3, unofficial conduct for which the president has no immunity. So we're gonna boom, because that's the wording that destroyed it all, everybody. That's the wording that ended it. Applying those principles to the original indictment, the Supreme Court concluded that Mr. Trump is, quote, absolutely immune from prosecution for the alleged conduct involving his decisions with the Justice Department officials, end quote, and involving his, quote, threatened removal of acting attorney general, end quote. The court also concluded that several conversations between Mr. Trump and the vice president constituted official conduct, but remanded for consideration of whether the office could rebut the presumption of immunity. As to several other allegations involving interactions with state officials, private parties, and the public, the court remanded for the lower courts to determine whether the conduct was undertaken in an official capacity or alternatively constituted a private scheme with private actors, as the office contended. The court also added an evidentiary rule to its immunity framework. Official conduct for which the president is immune may not be used as evidence in a prosecution for non-immune conduct. The court was concerned that, quote, jurors' deliberations will be prejudiced by their views of the president's policies and performance while in office, end quote. Justice Barrett joined the dissenters in disagreeing with that rule, noting, quote, the Constitution does not require blinding juries to the circumstances surrounding conduct for which presidents can be held liable, end quote. Standard evidentiary rules, she explained, quote, are equipped to handle that concern about prejudice from admitting evidence of a president's official acts on a case-by-case basis, end quote. I see no need, end quote, she wrote, quote, to depart from that familiar and time-tested procedure here, end quote. But you still went along with the decision. I don't understand. You still went along with it. Like, you still signed on it. It's fucking crazy. Part 3 of volume 5? Subsection Volume 5, Part B, Subsection 3. Unresolved issues regarding presidential immunity. The Supreme Court's decision raises several issues about the scope of presidential immunity that the lower courts and ultimately the Supreme Court would likely have had to address before the prosecution could have proceeded to trial. The following discussion illustrates some of the issues that the court's immunity decision left open and that remain unresolved given the required dismissal of the superseding indictment. First, while the court determined that certain core exercises of presidential power are absolutely immune and gave several examples, see 603 U.S. at 608, 609, pardon power, power to remove presidential appointees, power to recognize foreign nations, 620, 621, supervision of criminal investigations and prosecutions. It left undefined the full scope of that category. Compare at 620, relying in part on the president's responsibility to, quote, take care that the laws be faithfully executed, end quote, referencing the Constitution, to find that his investigative and prosecutorial decision-making and threats to remove the acting attorney general were absolutely immune. Relying in part to find that investigative and prosecutorial decision-making and threats were absolutely. So they did do that. And then Barrett talking about it, concurring, quote, I do not understand the court to hold that all exercises of the take care power fall within the core executive power, end quote. The office's position was that none of the allegations in the superseding indictment implicated core presidential powers. So they thought they got around that. Second, the court's decision accorded at least presumptive immunity to all non-core official presidential conduct. That holding left unresolved whether, at some future point, the court will determine that absolute immunity is required for that category of official acts as well. It also left unresolved the manner of applying its test for overcoming presumptive immunity. For example, that government must, quote, show that applying a criminal prohibition to that act would pose no, in another quote, dangers or intrusion on the authority and functions of the executive branch, end all quotes. We're just going to take that over for mine. In Justice Sotomayor's dissenting opinion, quote, according to the majority, however, any incursion on executive power is too much. When presumptive immunity is this conclusive, the majority's indecision as to, quote, whether official acts immunity must be absolute, end quote, or whether instead, in another quote, presumptive immunity is sufficient, end that quote, hardly matters, end all quotes. copy, paste. Okay, moving on. In its one concrete discussion of that test, the court described competing arguments about communications between the president and the vice president about the certification proceeding, noting that the vice president presides as president of the Senate, not in any executive branch capacity, and that the president has, quote, no direct constitutional or statutory role, end quote, in the certification proceeding. But the court stopped short of deciding whether any executive branch functions were in danger of potential intrusion in that setting and, if so, the nature of such functions. It also did not address whether de minimis intrusions would preclude rebutting the presumption, and how courts should make predictive judgments about potential intrusions. For example, by looking to history, speculating about future presidential behavior, or relying solely on legal materials. Following the remand to the district court, the office argued that, with respect to the presumptive immunity test, quote, the analysis should first identify the specific alleged act at issue and then determine whether criminal liability for the act intrudes on a relevant executive branch authority or function. Take care not to, quote, conceive of inquiry at too high a level of generality, end all quotes. The office's brief emphasized that this approach, quote, recognizes that executive authority has limits, boundaries opposed by constitutional text, the separation of powers and precedent, and that application of criminal law to the president's official conduct does not per se intrude impermissibly on executive branch authority and functions, end quote. With regard to the communications between the president and the vice president, the office submitted that, quote, because the executive branch has no role in the certification proceeding, and indeed the president was purposely excluded from it by design, prosecuting the defendant for his corrupt efforts regarding Pence poses no danger to the executive branch's authority or functioning. Third, in discussing the process of separating official from unofficial conduct, the court wrote that the analysis is, quote, fact-specific and may prove to be challenging, end quote. The court's discussion of a president's public communications illustrates those challenges. The court directed that the status of a president's public communications should be assessed through an, quote, objective analysis of, and another quote, content, form, and context, end all quotes. It also cautioned that, quote, most of a president's public communications are likely to fall comfortably within the outer perimeter of his official responsibilities, end quote, while stating that there, quote, may, end quote, be contexts in which a president, quote, speaks in an unofficial capacity, perhaps as a candidate for office or party leader, end quote. The court's analysis recognized that, in principle, there is a line between a president's official and non-official communications, but the court gave little detail about when an incumbent president crosses the line between his official role and his candidate role. So it's a super tough issue, and they're not giving specifics about it. In Sotomayor's dissenting opinion, quote, in fact, the majority's dividing line between, quote, official, end quote, and, quote, unofficial, end quote, conduct narrows the conduct considered, quote, unofficial almost to a nullity, end all quotes. Upon remand, the office argued that, quote, at its core, the defendant's scheme was a private one, end quote, and that in proving the case, the office would rely on, quote, public campaign speeches, tweets, and other public statements and comments, end quote, that Mr. Trump made, quote, not as president, but as a candidate for office, end quote. Finally, as noted, the court's decision that the presidential immunity precludes the introduction of evidence of immune official acts even in a prosecution for unofficial conduct left open substantive and procedural questions. In responding to Justice Barrett's disagreement with the court's evidentiary holding, in which she highlighted her concern about excluding official act evidence in, for example, a bribery prosecution, see Barrett concurring in part The court wrote in a footnote that in a bribery prosecution, quote, of course, the prosecutor may point to the public record to show the fact that the president performed the official act, end quote. Majority opinion, quote, what the prosecutor may not do, however, is admit testimony or private records of the president or his advisors probing the official act itself, end quote. Those statements create uncertainty regarding which types of evidence of official acts can be used and which cannot. A further procedural issue involved the scope of any interlocutory appeal from the district court's ruling on immunity. The Supreme Court had emphasized that immunity issues should be, quote, addressed at the outset of a proceeding, end quote, and presupposed that, quote, a district court's denial of immunity would be appealed before trial, end quote. While the parties in the district court agreed that whether the superseding indictment states an offense based on non-immune conduct would be subject to a pretrial interlocutory appeal, the evidence component of the court's immunity ruling left open the question of whether evidentiary determinations regarding potentially immune evidence could be appealed before trial. Further proceedings on remand likely would have provided guidance on this and other issues described above. But they didn't get a chance to, didn't run their course. We have made it to the conclusion. If you have made it this far, I think we did a little preview of this, but now we are going to rip through the conclusion real quick. Really thank you for sticking along with us. All the precedent is the references are listed here below, some precedent, some other statements and stuff like that. So if you want a full view, just look down through there, but we are just going to rip through the conclusion real quick for everybody. And then we're going to hop into some games. We're going to have some fun because we said some games in the background. We might get into some, and we got some time. So why not? All right. We are at Volume 6, the conclusion. We made it. If you stuck around this long, thank you so much. We really appreciate you. If you're watching afterwards, we appreciate you as well. On remand from the Supreme Court's decision in Trump, the district court set a litigation schedule whereby the parties would submit briefs regarding whether any material in the superseding indictment was subject to presidential immunity. ECF number 233. The parties were in the middle of that process when the results of the presidential election made clear that Mr. Trump would be inaugurated as President of the United States on January 20th, 2025. As described above, it has long been the department's interpretation that the Constitution forbids the federal indictment and prosecution of a sitting president, but the election results raised for the first time the question of a lawful course when a private citizen who has already been indicted is then the sitting president. The department determined that the case must be dismissed without prejudice before Mr. Trump takes office, and the office therefore moved to dismiss the indictment on November 25th, 2024. The district court granted the motion the same day. The department's view that the Constitution prohibits the continued indictment and prosecution of a president is categorical and does not turn on the gravity of the crimes charged, the strength of the government's proof, or the merits of the prosecution, which the office stands fully behind. Indeed, but for Mr. Trump's election and imminent return to the presidency, the office assessed that the admissible evidence was sufficient to obtain and sustain a conviction at trial. Boom goes the dynamite. And that's it. That is the Jack Smith report. Anybody who... You can see all their work here. Scrolling down. Is this different from the top one? Let me check and make sure. Ooh, it's a different letter at the bottom. Okay. There's a letter at the bottom. Let's see what he writes in his letter. Maybe he gets sassy. If it was me, I'd get sassy. I don't know. We're just gonna rip through it, just for shits and giggles. It's short. It's here. If it's repeating it, who cares? It's what's at the end of the document. So delivery by hand, blah blah blah. Dear Mr. Attorney General, from the Office of the Special Counsel. As you know, my office provided counsel to Mr. Trump, Mr. Nawada, and Mr. De Oliveira, all these people, an opportunity to review the draft of my confidential report and to provide any response in writing by 2 p.m. January 6, 2025, so that my office could consider any issues that counsel identified in the final report before officially transmitting it to you. Only Mr. Trump's counsel chose to provide a written response in the form of a letter to you. That response fails to identify any specific factual objections to the draft. Instead, Mr. Trump principally objects to the public release of the report and, in service of that objection, makes a variety of false, misleading, or otherwise unfounded claims. So he doesn't want it spread. That's why we're doing it. If for no other reason, to just have a good time doing what they don't want us to do, because fuck them. While the determination as to whether to publicly release the report consistent with applicable legal restrictions is yours as Attorney General, I felt it necessary to address below certain inaccuracies set forth by Mr. Trump's letter. As an initial matter, the office extended Mr. Trump a special accommodation by allowing his counsel to review a draft of the report. Such an accommodation is not required under the law or regulations. Nonetheless, the office elected to provide Mr. Trump's counsel access to the draft report through what it understood to be a process similar to that employed by special counsel Robert K. Hur. So they're just going by past precedent here. By allowing counsel to review the draft in person over the course of 4 days in the office's workspace without contemporaneous access to personal electronics, but with the ability to take notes, including the use of government laptops on which to draft a response. Specifically, on December 11th, 2024, Mr. Trump's counsel requested an opportunity to review the report before it was submitted to the Attorney General. On December 15th, 2024, the office informed Mr. Trump's counsel that it would make arrangements for counsel to review the draft report and provided a range of dates when the review could occur. After Mr. Trump's attorneys complained that the initial review dates that the office offered conflicted with their vacation schedules, gotta love it, the next day, the office changed the schedule to provide that dates they requested. It was surprising and disappointing to see Mr. Trump's grievances about these accommodations in his letter, see Trump letter at 2 and 3, especially after Mr. Trump's counsel explicitly stated their, quote, genuine, end quote, and, quote, personal appreciation, end quote, to the office for the new dates in a phone call on December 16, 2024. So, just real class at every step. Mr. Trump's other criticisms for the review process are similarly disingenuous. For instance, he complains that he was prevented from reviewing the underlying documents cited in the draft report. But over the 4 days Mr. Trump's attorneys were given to review the report, they never requested access to a single underlying document, despite the fact that the office had attorneys on hand specifically assigned to respond to any questions counsel might have. Relatedly, Mr. Trump insinuates that the office improperly, quote, demanded, end quote, that counsel delete discovery productions prior to their review of the draft report, when in fact that deletion was required by the protective orders that federal judges entered in both of Mr. Trump's criminal cases. In sum, Mr. Trump's counsel had full opportunity to review the draft report and only came to the office to review it on the first 2 of the 4 days available. Upon completing the review, Mr. Trump has not contested a single factual representation in the report, instead objecting only to its public release. So they don't even argue against these things. They know they did this, they know they stole it, and they don't even argue against it. It's trash. They're trash people. They just don't want you to see it. And that's why we have to tell you about it. Other complaints by Mr. Trump are addressed and rebutted by the report and court decisions. For instance, Mr. Trump recycles his baseless allegation that the office's work constituted a partisan attack, a claim flatly rejected by the only court to have ruled on it. See United States v. Trump, the specific precedent, DDC, August 3rd, 2024, denying Mr. Trump's motion to dismiss indictment based on selective and vindictive prosecution, quote, finding no evidence of discriminatory purpose, end quote, no evidence demonstrating a likelihood of vindictiveness, quote, end quote, and, quote, no evidence that would lead the court to infer that prosecutorial discretion had been abused, end quote. Internal quotation omitted. The report explains in detail the office's steadfast adherence to neutral and even-handed application of the law and to the department's election year sensitivities policy. Mr. Trump also persists in his challenge to the Attorney General's authority to appoint a special counsel, which is subject of a pending appeal in the 11th Circuit. See United States v. blah, 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 bunch of bullshit, 11th Circuit. As explained in my report, the office is confident that the department has strong arguments to prevail on that issue. Finally, Mr. Trump's letter claims that dismissal of his criminal cases signifies Mr. Trump's, quote, complete exoneration, end quote. That is false. As the office explained in its dismissal motions and in the report, the department's view that the Constitution prohibits Mr. Trump's indictment and the prosecution while he is in office is categorical and does not turn on the gravity of the crimes charged, the strength of the government's proof, or the merits of the prosecution, all of which the office fully stands by. Sincerely yours, Jack Smith. You gotta love it. Touch of class all around. You gotta love it. That is the full Jack Smith report. Boom, boom, boom. Oh.